My lords, my lady, thank you very much. It was me that briefly held you up, for which I apologise.
As long as we stick to the timetable, that's fine. Right, where do we go from here?
So, on the assumption that the CPR Part 55.82 test, which the defendant has to satisfy in order for the case management directions to have been made, and for the district judge not to be able to decide the case summarily, is a test which is similar to the summary judgment test. Miss Laleva had to establish that she had real prospects of success in her defences.
Yeah.
So how did the district judge deal with that? The district judge's transcript of judgment is at divider 9.
Yes. I don't think we've got dividers, but it starts at page 98.
I apologise. It starts at page 98, my lord, yes. So really she deals with the defence which is on Judge Luba's order. Maria Laleva was allowed to continue to defend the claim or dispute the claim at paragraphs 7, 8 and 9.
Yeah.
So paragraph 8, on page 100, my lords, my lady. The second issue is the tenure of these defendants, whether they have a licence or a tenancy, and whether the agreement is essentially a sham. The agreement and the clauses in the agreement, which were in the bundle, I was satisfied supported the proposition that this was a licence. They were incompatible with the argument that these defendants were granted exclusive possession of their rooms. Yeah. This was supported by the contextual information to the background of the case that this was formerly a nursing home, then offices owned by the NHS, and required to develop as a health centre.
So that's as a matter of construction of the agreements.
That's right.
Against the admissible background.
By reference to what was said in the defence.
Yeah.
The defendants made, paragraph 9, the defendants made the point that the case law, especially Camelot Guardian Management Limited and coup, will never be full square with every situation. I obviously accept that, but I was satisfied that in all essential points, the facts of this case are in line with the Camelot the coup judgment. I am not satisfied from the defendant's pleading that there is a substantial defence that this was a sham agreement. So they're making it clear that she had regard to the pleading. It was not adequately pleaded as a sham or a fraud. There was no total unreality aspect here. In fact, the opposite was true. It was readily understandable that this was a licence and the reasons for that.
Yeah.
So what I propose to do is take you to the defence, which is at page 104.
Yes.
The defence which Maria Laleva was allowed to pursue is really set out in paragraph 2, which covers a page 104 to 106. Do you want me to read that, or shall I leave you to...
We've read it.
Pardon?
I've read it.
I'm obliged. So in my submission, that clearly sets out that Maria Laleva was accepted that her occupation of the rooms that she occupied after the 17th of April 2020 was pursuant to the licence agreement and the terms of it. She doesn't say this wasn't what was agreed between us, or that the licence doesn't give effect to the relationship. So, for example, at paragraph, under the particulars at page 105, little Roman 1, paragraph G, right at the bottom of the page, the pleading says the purported contractual clauses at paragraphs 1.3 to 1.5, etc., of the written agreement between the parties are not incompatible with exclusive occupation. It doesn't say they weren't what was agreed, it says they're not incompatible with exclusive occupation. So in effect, I accept that those were the terms, but they don't give rise to the proposition, or they don't establish conclusively that I was a licensee and not a tenant.
Well, you might also say, echoing one of the things that Mr. Wonnacott has been stressing, she doesn't actually say she was granted exclusive possession.
No. And what's more, in response to Mr. Wonnacott's argument, she doesn't say she's a squatter because she accepts that she's in occupation pursuant to the terms of that agreement. So if it was someone who was trying to establish an adverse possession claim, this isn't a case where she is saying I was in occupation, so Pye and Graham, the licence had ended, but we remained in occupation. We were willing to enter into a licence if one was proffered to us. In this case, she's accepting that she occupied pursuant to the agreement that was proffered to her. So she's not, in that sense, a squatter who is asserting adverse possession, and therefore perhaps isn't somebody who says, I have title by reason of my possession. But that's in response to Mr. Wonacott's argument. So His Honour Judge Luba, at page 59, deals with the licence tenancy point. And at paragraph 80, you'll see he sets out that part of the defence that I have taken you to. And over the page at paragraph 83, paragraph 83, I apologise, page 60, he sets out the two substantive paragraphs of the district judge's judgment. And what he then says at paragraph 84, it is important to recall that the judge had no evidence in the case beyond the short witness statement filed in support of a claim against trespassers and the exhibit to that. Well, that's wrong. The district judge expressly stated that she had the licence agreement which the parties accept was the basis upon which Maria Laleva was let into occupation, and so she did have evidence before her. And it's clear in my submission that the district judge took the defence at its highest. So she didn't need any evidence from the defendant at that point, because what she was doing was accepting, in the way someone would on an application for summary judgment against the defendant, she was accepting that the defence, insofar as it was raised facts that were not pleaded by the claimant, would be made out.
Well, up to the point, she didn't accept that the sham would be made out.
And I'll come to that.
Yeah.
I'll come to why that was absolutely a finding that she could have made. At paragraph 89, His Honour Judge Luba says, in particular, I note the occupancy of the premises by Miss Laleva began before the parties each signed the licence agreement now relied upon, and that the premises she occupies were not a former warehouse or some other empty commercial building, but a property with a history of use for residential occupation. So that is right. Maria Laleva had entered into occupation of other rooms in the premises before the licence was signed, but her case is that when she moved her rooms to other rooms, she signed the licence agreement, and she doesn't say the licence agreement must be construed in the light of the fact that I'd had a tenancy previously, an unwritten tenancy, and there can be no derogation from grant or anything like that. What she says is those written terms were the terms of our agreement. So that was an irrelevant factor that His Honour Judge Luba took.
Yeah, I mean, on the 17th of October, the agreement was signed. We can see that from page 253.
April, I think.
So April, I beg your pardon. And that is the date on which Miss Laleva says she moved into the room.
Yeah.
So she signed the agreement relating to that room on the day she moved into it.
Yeah. So His Honour Judge Luba there, in finding that the district judge had got it wrong, took into account a factor that hadn't been put in issue or wasn't relied upon by Miss Laleva. Insofar as the building previously being residential premises are concerned, Miss Laleva's own defence says they were a nurse's home. But in the interim, before I was granted my tenancy, my occupation right, they were used as offices. So that's at page 105, paragraph particular Little Roman 1A.
Mm-hmm.
And so again, in my submission, His Honour Judge Luba was wrong to rely on that as giving rise grounds for the basis for finding that the district judge was wrong. His Honour Judge Luba then says, sorry, it's paragraph 88, I apologise, just before that. In the present case, the terms of the licence agreement entered into by Ms. Laleva may have been similar or perhaps even identical to those of the Camelot case, but that did not foreclose her from contending that in the circumstances of her particular occupancy, she actually enjoyed a tenancy and that the licence agreement either innocently mislabelled the relationship or was a sham. And he said, with respect to the judge, I do not consider them to inevitably dictate the result of the lease licence point in this claim. And in my submission, His Honour Judge Luba was wrong in not starting with the terms of the agreement.
Yeah.
So that's at page 253. My Lord, the clauses that we refer to as clearly indicating that it was a licence and not a lease are set out in the replacement skeleton argument. I apologise, they're not. They were set out in the argument before His Honour Judge Luba. I apologise about that. I'll take you to that in a moment. But if you read the recital, if I can call it that, under the words temporary licence agreement.
So which page are you at now? Sorry.
Page 253, my Lord, sorry. And then on that same page, the clause above the words 1.1, the clause below the number 1.3, guardians have no right to bring other people, and the clause below the number 1.5, this agreement does not give the guardian a right.
Yeah.
At page 255, there's a heading, the guardian will not, 2/3 of the way down the page. There's the heading for those.
Is there any significance in clauses 4.1 and 4.2?
My Lord, there are, but I don't think I need to. I think that the other clauses in the agreement are stronger in relation to this creating a licence and not creating a tenancy agreement.
So we're going guardian will not, yes?
Yes, the guardian will not. So,
as Mr. Wonnacott said, it is not the draftsman's finest hour.
No, it
start
isn't.
with clause 5 and then we move to 4.8.
we do. I think what has happened is that so if you go back, you'll see there was a clause 4 over the page, back of page at 254, and those clauses that have the prefix 4.8, 4.9 and 4.10 are under that heading.
Yeah, well, clause 4 then starts with 3.1.
Yeah.
Doesn't help.
But 4.1 is sleep at the property for at least 5 nights.
Yeah.
I would refer you, my Lord, So 4.3, which is share the property amicably and peacefully in common with such other persons as G100 shall from time to time permit to make use of the property and not interfere with such shared occupation in any way whatsoever.
Right. And he wanted us to look at the guardian will not.
The guardian will not. 5.9.
5.9.
Just out of curiosity, 4.9 can't be right.
Sorry, that's under the heading 4. So it's not a. So if
Well,
you.
it says the guardian will not advise G100 immediately, etc.
I understand.
Or keep it clean.
So, my lord, if I can explain that. Those clauses that have a prefix number of 4 are provided for by the heading.
Oh, the guardian will.
The guardian will.
So the headings are in the wrong place.
Yes.
Right. Yeah. Okay. Sorry. Yep.
Well, win, lose or draw, your clients really need to revisit this documentation.
Yes. Yeah, no, that.
So 5.9, yeah, anything else?
.11. Invite persons less than 21 years old into the property.
Mm-hmm.
And then over the page at page 259, there's a heading signing this agreement, which is section 12 or clause 12 of the license agreement. In order to find that, you have to go to the end of the clauses that have number 11 as a prefix, and you find those on page 260. And number 3 provides, my lord, you are not being given exclusive occupation of any part of the property or the right to exclude other guardians or G100. The area that you use will be regularly inspected without notice, and videos of those inspections may be taken and stored on the system. Number 4, this is not a tenancy agreement and you obtain no tenancy rights, and you will have to leave the property as soon as this agreement is terminated for whatever reason. And, going back to number 2, the living space will be shared with other persons and you will have to agree with those other individuals how the space is to be used.
What is the living space with a capital L and a capital
So the living space is defined as, in effect, the whole of that whole part of the property which was identified by G100 as being the areas in which...
Yeah, but is it defined in this agreement?
It is.
Where?
I need to find it.
It's 13.3 at 262.
Sorry?
262, 13.3.
262.
Thank you very much, my lady.
Sorry, where? Where's the living space defined?
262, my lord.
13.3.
Oh, yes. So that's the shared use.
That is that part of the property.
Yes, but that's the shared bit.
Well, it's all of it because it's all shared. And people are designated rooms.
Right. Right.
So what does 1.5 mean then at 253? Doesn't give the guardian a right to use any specific room as living space.
Yeah.
Guardians will be allocated a space within the property. What's the difference between a room and a space? What do they get?
So each guardian has a room that is, excuse me, theirs, and we know from Maria Laleva that she moved room from the room that she originally occupied to another room. And
is it trying to say that they can't claim any particular room for any period of time? They are told from time to time by G100 which room they can occupy.
well, if you carry on, if you read the rest of the clause under the number 1.5, that is what it in effect says this is subject to the right of G100 at any time from time to time to decide which room any one or more of the guardians may use as their space.
So if one used a hotel analogy, and I appreciate it's not a good analogy necessarily, but when you check in, you're given a certain room at the choice of the hotel. You can't say, I want a particular room. You're just given a key card and told you're going to room 412.
That's right.
And this says, at some point, somebody could knock on the door and say, sorry, we're moving you to 314.
That's right.
Right.
And indeed, I think that's, if you look at the defence, that is largely what happened. So if you turn to page 105, paragraph Roman 1 little c, rather than occupying the whole space in common with the other residents, the Sixth Defendant was required to seek the claimant's permission to move room.
Although it then goes on to say at E, she selected her own room rather than being allocated room by the claimant.
So there is, the arrangement is that each of the guardians, or where there are couples of guardians, they have rooms which are nominally theirs, but they are all part of the living space and they can be moved within the premises. So the proper approach in my submission is the one set out by Mr. Justice Butcher in Camelot and Coup, which is behind tab 22 in the bundle authorities. And I'm dealing now with both the construction of the agreement as to whether or not it created a tenancy or a licence, and the argument that it was a sham. And paragraph 18 is at page 429 of the judgment. 382 on the bundle paginating.
Yeah.
Paragraph 18 I won't read, but paragraph 19, Mr. Justice Butcher said as follows: in determining whether an agreement creates a tenancy or a licence, the approach of the courts is, as I understand it, as follows. The court will begin by construing the agreement between the parties to consider whether it creates a tenancy, including in particular construing to see whether it confers a right to exclusive possession. In the process of construction, number 2, sorry.
You don't need to read it aloud. Do you want us to read the whole of the paragraph?
Yes, please. So the importance of the agreement, in my submission, was paramount, and it's clear that the district judge did have regard to the terms of the agreement, whereas the circuit judge considered that he couldn't determine the case on a construction of the agreement by reference to what the defence said about it. And indeed, my learned friends in their skirting argument say, well, there's evidence. Maria Laleva wants to produce evidence, but they don't anywhere say what evidence she would produce, what she would say to establish that the terms of the agreement shouldn't be construed on their face.
Well,
which is the starting point.
There are two separate points on there. The first is, what does the agreement mean?
Absolutely.
and having decided what it means, whether the clauses which the parties have agreed amount in law to a licence or a tenancy. And on that question, evidence other than evidence of surrounding fact is not admissible.
My lord, yes.
Second question is, was this a genuine agreement, or was it a smokescreen, sham, whatever you want to call it,
My lord, yes.
a real agreement on which her evidence would be admissible?
My lord, yes. So, on the construction of the agreement, the district judge had all that she needed. In relation to the sham argument, if you look at the way in which that is pleaded in the defence, page 106, and it's little Roman 2, it's part of the particulars to paragraph 2. Further, alternatively to subparagraph 2, Roman 1 above, the written agreement between the parties, insofar as it purports to be in the nature of a personal licence rather than tenancy, is a sham arrangement, and that in consequence of the factual realities of the arrangement, as set out in subparagraph 2 above, the purposes of terms of the agreement on which the claimant seeks to rely, insofar as they may be incompatible with exclusive occupation, was to create the appearance of a personal licence. So that's Maria Laleva's case on sham. The district judge was entitled to have regard to the factual circumstances of the creation of GGM's head licence and the grant of the guardianship licences to the guardians. The position is that if NHS Property Limited wanted the property back, they had to give 4 weeks' notice to Global Guardians Management, and no more. So, in those circumstances, that is strongly supportive of the proposition that what was being granted were licences, and this was not a sham agreement. Indeed, if you compare the arrangement that was arrived at here with the two sets of circumstances described in AG Securities and Vaughan, and Antoniades and Villiers, which is behind tab 9 in your authorities bundle, my lords and lady. The facts are really set out in the head note.
What are you citing this proposition, this for? What proposition to get out of it?
Well, that an arrangement where a group of unconnected people, or they're not a group, sorry, where unconnected people are given right to occupy premises for the purposes of performing the service of guarding them in circumstances where the company granting them the licenses has entered into an arrangement for guardianship with the owner of the property, is, in my submission, clearly not a sham. That the idea that the guardians should be granted licenses is patently not a sham.
How do you get that out of AG Securities and Vaughan?
Because in AG Securities and Vaughan, the argument on behalf of the occupiers was that they had exclusive possession collectively, and it was found that they did not have exclusive possession. The case of Antoniades and Villiers concerned an arrangement whereby a couple who were effectively living together,
required to share the bedroom.
Yes.
And they said that's an obvious sham.
That's an obvious sham. And so, in this case, the agreement is not merely just like the AG Securities and Vaughan position, it's actually even stronger than that, because in the AG Securities and Vaughan, there was no guardianship arrangement with the owner. The owner was the company granting the licenses to the occupiers. What they had was a six-room flat, and they granted 4 separate occupiers.
Well, we don't know, do we, how many guardians there were in this building?
Well, we know what the claim. We know that the claim was brought against 11 people.
Oh, I see. Right. Yeah. Fair enough. Yeah. Yes. Right, and it's not alleged by Mr. Laleva that they are 11, so to speak, pre-connected people.
No.
No, right.
And you'll see the defence accepts that there are other residents in the building, because at paragraph Little Roman 1c at page 105, he says, rather than occupying the whole space in common with other residents, the Sixth Defendant was required to seek the claimant's position to move room.
Yeah.
So indeed, it's in fact her case that she didn't occupy the whole of the property, other than her 2 rooms. Exclusive. She claims a tenancy only of the 2 rooms that she says she has exclusive possession of.
Yeah. 2 rooms, is it? Not just room 2?
It's room 2. I apologise. It's not 2 rooms. No, it's that's my misreading. It's later room 2 on the first floor. That's at page 105, Roman 1b.
Yeah. Yeah. A numbered lockable room.
A numbered lockable room. So, well, there was no basis for the circuit judge to find that the district judge was wrong to the necessary extent to have made a possession order at the first hearing on the basis that the defences made out in the defence of Maria Laleva did not give rise to a genuine dispute on substantial grounds. Those are our submissions, Will.
Right, thank you.
No, thank you.
No, thank you, Mr. Grundy.
My name, my lords.
Are you dealing with this, or is Mr. Barno going next? How are we?
I'm going to do 5 short points of reply on the cross appeal.
Yes, of course.
And then Mr. Barno is going to take over and respond to the appeal.
Right.
So the 5 short points of law are, first of all, my old friend cited Bruton and London and Quadrant. And he said that if I'm right, Mr. Bruton could have terminated the tenancy, sat tight, and said that London and Quadrant had no title. Well, he couldn't have done that if London and Quadrant had accepted that he was a tenant, because then both parties would be estopped for saying there's a tenancy. Any more than if Global accepted that I was a tenant, I'd be able to say they didn't have title. But if London and Quadrant had brought a possession action against Mr. Bruton alleging that he was only a licensee, then yes, Mr. Bruton could have said, strike this out at the first hearing. That's not a sufficient title. So that London and Quadrant was only a licensee. Mr. Bruton could say, yes, strike that out at the first hearing. I don't need to respond to this claim because you do not have a sufficient, you haven't alleged a sufficient title to be able to bring it. Very brief point on Alamo and Meredith, which was the second post-Dutton case in this court, and that's simply that only 2 cases were cited in argument in that case, and they were Dutton and Alamo.
Dutton and Allen?
And Alamo.
Alamo.
Yeah, Alamo was the first one. Sorry, Dutton and Countryside Residential.
Right.
Countryside Residential and T was the first one where there was a challenge by,
Yes.
and the court said you don't need to deal with the challenge, deal with the other point, and it was dealt with. And then Allen and Meredith comes along, and the only two cases that are cited there are Dutton and Countryside Residential. And the argument is between whether it's a Dutton case or whether it's a Countryside Residential case, there is no challenge to Dutton in that case on the basis that it was per incuria.
Yeah.
The third point of law is on Mayor of London and Hall, which is at tab 16 of the bundle. Could I ask you just to look briefly at that? This was the Parliament Square protest case. It all sort of comes back with a Proustian rush. You were taken to paragraph 27 of the judgment of Lord Neuberger as some support for the proposition that Dutton was rightly decided. Could I just ask you to read paragraph 26 as well?
Yes.
So it's very much on the one hand, on the other.
Not untypical of that judge.
No, not untypical. And one gets the feeling that he was relieved that he didn't have to decide the point. The fourth point of law was on Asta. My learned friend says, if I'm right, that means the effect of Asta is that a person can get a possession order regularly and then enforce it after he no longer has any interest.
I must say I didn't understand
No,
this.
well, maybe that's right, maybe it's wrong, but it's got nothing to do with this case. And then finally, Tadman and Hedman.
Sorry, which one?
Tadman and Hedman.
Oh yes, Mr. Justice Charles.
Is Mr. Justice Charles. And it was suggested that he had supported a wide interpretation of what's meant by the estoppel between a licensor and licensee. Could I just ask you to go to page 171 in the report? And about 5 or 6 lines down, he cites Dell and the demise of Johnson and Baytup at the end of a line. And then he says, this is what he takes his authority for. It was there held that a person who had got into possession of premises by the licence of the lessor of the plaintiff, Mrs. Johnson, could not defend an ejectment, but was stopped from disputing the title of the lessor of the plaintiff. That's Mrs. Johnson. And in that respect, there was no distinction between a tenant and a licensee. So he actually supports the narrow interpretation.
Yeah.
My lords, unless you've got anything else on the cross appeal, I think that brings us to my old friend Mr. Barnett.
Thank you very much, Ms. Swan. So, Mr. Barnett, you're going to deal with an appropriate test under Part 55.
My lord, yes.
And whether there is a defence to whatever the right standard is,
Yes.
either because this in fact creates a tenancy or because it's a sham.
My lord, that's right. And dealing with the first of those, if I may, and just to say what our case is on the third issue, we say that Part 55(8)(2) is a lower test than summary judgment. It's an arguable threshold, an arguability threshold. Or if we're wrong about that.
Arguable?
Yes. Or if we're wrong about that, then it's certainly no higher than the test for summary judgment. And could I start, if I may, with the authority that my Lord Justice Lewison brought to our attention, Lady Justice Arden's judgment in Collier and Wright, and it's tab 31. You've seen it before.
Yeah.
And you've seen that Lady Justice Arden sets out the tests for applying to set aside statutory demand. Very, very similar terms to 55.8. It doesn't answer this appeal, in my submission, not because of the difference in the word, but because of the difference in the context. Setting aside a statutory demand, the insolvency rules required and still do require evidence, formerly an affidavit, now a witness statement. And if we see what Lady Justice Arden actually then was said, it's at paragraph 21. on page 477, and that's 652 of the report. And just before 21, Her Ladyship cites High Court authority. It had been thought that setting aside the correct test was arguability. She says that's wrong. At 21, she says we don't follow the High Court. But over the page, she explains why. At 5b, Her Ladyship explains that it's not an arguability threshold. In my judgment, the requirements of substantiability, if different to genuineness, would not be met simply by showing that it is arguable. But she says there has to be something to suggest that the assertion is sustainable. The best evidence would be incontrovertible evidence to support the appellant's case, and then goes on to say that some evidence at least is necessary. So that's in a context where evidence is specifically required. We are in a context where evidence is specifically excused.
Specifically?
Excused. There's no requirement to file evidence.
Yeah.
There's no requirement to file any statement of case. An occupier can turn up at a hearing and take part. So Collier and Wright, in my submission, doesn't give us a complete answer. So we do need to find our own. And the starting point for that, if I may, unless my Lord Justice Snowden has a question.
So, what's your authority for the proposition that? Sorry, are you saying that there needs to be evidence filed?
Yes, under the insolvency rules, and forgive me for not including them in the authorities bundle, but this was a late addition to the authorities bundle. Previously under the 1984 Act, and now under the 2016 regulations, an application to set aside a statutory demand must be supported by evidence.
And you say that differs from the CPR Part 55 regime?
That's right. There's no, as the judge below points out, and as is pointed out in the authorities which we'll come to, under Part 55, there's no requirement on a tenant or an occupier to respond to the claim in any way before the hearing. He or she may still take part.
But
that's just a timing point. Sorry.
Yeah, that doesn't solve the question. If somebody turns up at the hearing out of the blue, says, I'm occupying this property that you're claiming, and I want to put in a defence, then the court, normally speaking, would say, all right, well, we'll give you some time to do that. But that's a different question from what the position is after the defendant has put in a defence. And the court then says, well, now let us evaluate that defence and see if it amounts to genuinely disputed on substantial grounds. They're two quite separate processes. The fact that you can turn up without having put in a defence doesn't tell you, once you have put in a defence, anything about the test that the court is going to apply.
As a matter of practice, that's often right. But the rules allow, and indeed require, the court to consider whether the claim is genuinely disputed on grounds that appear to be substantial, whether there is a defence or not, whether there is any evidence or not. Very often the courts say, file the defence and we'll think about it, but the rules allow and sometimes require the courts to consider what the tenant is saying on assertion alone, unlike in the insolvency context.
If somebody turns up at the first hearing and says, as I understand is fairly commonplace, I've only just got this, I haven't had any time to take legal advice, or I want some time to get my act together, as a case management decision, they would generally be given the opportunity to do that. And at the next hearing, the court will evaluate whatever they have produced, whether it be a defence signed with a statement of truth, which it was in this case, I assume, although we've got a draft. I assume it was signed with a statement of truth.
It was unsigned, my lord. It was a draft defence.
I assume it was treated as if it was evidence because it's signed by with the statement of truth, or, in fact, a witness statement or something like that.
Yes.
That's not. Why is that different from the situation where, if somebody wants to set aside a statutory demand in bankruptcy, they frequently turn up in front of the registrar and say, I'm outraged, I've just been served with a statutory demand in bankruptcy, I need some time to put in a witness statement to say that the debt is disputed. They're given an adjournment and then they turn up with a witness statement and it's evaluated. I'm not sure I understand, other than some sort of timing point, what the difference is by the time the court comes to make a decision.
Well, my lord's quite right that very often the court will say, the district judge will say, go away, file the defence, file some evidence, or think about it. But it's also very common for a tenant to turn up and say, this is what my defence is going to be, and the court to then give direction to trial or decide that this defence, as it's framed, is not a substantial one.
Well, when the court gives directions for trial and there is no defence filed, it is almost bound, is it not, to give directions for a defence?
Yes.
Once that defence has been filed, are you saying that the claimant cannot bring an application for summary judgment?
Quite the
He
opposite.
said, I've seen the defence, now I'm going to bring an application for summary judgment. So, what benefit is there? Once a defence has been filed, what benefit is there in having some different test?
The court may well take, the claimant may well take the view that a tenant, having got through a first hearing, has filed a defence that doesn't come up to scratch, and may then apply for summary judgment. But the first hearing is much more investigative. It's much more inquisitorial, as my own friend put it. The court needs to see if there's an issue there.
Well, in this case, we know there was an issue. We know because it's in the defence.
Yes, yes. And in this case, one can understand why the landlord didn't apply for summary judgment, because timing is everything in a case like this. But in a long-running case, like Ackerman Livingston, for example, the landlord might at some point have said, there is a defence, we can all see what the defence is, we don't think it passes the summary judgment test. We're applying for summary judgment. Could I cite authority as to why I say this is correct?
Right.
And I'll start, if I may, with Ackerman Livingston itself, and then show my lords the High Court authorities. I'm sorry, my lord.
Just before you
Yes.
do, sorry, I'm just trying to understand why you say 55.8 operates in the way you appeared for me
Yes.
to do. I mean, it says at the hearing fixed in accordance with Rule 55.51 or at any adjournment of the hearing, the court may decide the claim or give case management directions.
Yes.
I mean, that covers absolutely every eventuality, both at the first hearing, the second hearing. You don't have to set it down for trial. You can create a situation in which whatever the defendant wants to put in, they put it in order for the case to the court to decide, is there a genuine dispute on substantial grounds?
Yes.
Or not?
Sorry.
Or not?
Yes.
I mean,
That's right. The rules allow for everything, every eventuality. What sometimes happens is a defence is ordered at an early stage. What sometimes happens is the court accepts, without a defence having been filed, that the claim should proceed to trial and a defence is filed in due course. The court sometimes operates on the basis of documents filed by the tenant, sometimes it doesn't.
but I was trying to understand why you say this is fundamentally different, a distinction from the position that would apply in a application to set aside a bankruptcy petition, where, as my lord has put to you, however you got there procedurally, and each regime is flexible enough to get there, you actually have material in front of the court on which the court can then evaluate to decide whether there is a genuine dispute on substantial grounds.
Yes, I see the point, my lord. And I was simply pointing out that the difference is, if there is a formal difference, there is a specific rule in the context in which Lady Justice Arden was discussing for evidence at the start.
Yeah.
There is no such requirement in the housing possession context.
Okay.
No.
My
Right,
lord,
you wanted us to look at Ackerman. You
Yes.
wanted us to look at Ackerman.
I do, because this, I say, is the best authority on the test, because what Lord Neuberger says about it in the context of discrimination applies equally in the context of disputes such as this one about tenancies versus licences. It's
Right.
behind tab
20.
20, my lord, I'm grateful, and it's Lord Neuberger's judgment, with whom all of the members of the court agreed, at paragraph 60, which is on page 362 of the bundle, and in the report it's 1425.
60. Yeah.
And what I say, my lords, my lady, is that we can read this principle across the lease licence disputes. The problem is a practical one, because each of the three types of issue, and here he's talking about discrimination, referred to in the immediately preceding paragraph, would often give rise to disputed facts or assessments, for example, and then he lists those pertinent to discrimination. Summary judgment is not normally a sensible or adequate procedure to deal with such disputes, which normally require disclosure of documents and oral or expert evidence tested by cross-examination.
Well, I think we need to read it in conjunction with paragraph 59.
Yes.
Where he says that doesn't mean a landlord whose claim is met with a defence, the effect of possession is being sought because of something arising consequence of disability. So we've got a defence here, that's the defence.
Yes.
Cannot obtain summary judgment, could be ordered summarily if a landlord could establish, one, the defendant had no real prospect of establishing he was under a disability. Two, it was plain that possession was not being sought because of something arising in consequence. And in any event, the claim was proportionate.
Yes.
So there's nothing to stop the landlord having summary judgment if there is no real prospect of establishing that something is a tenancy as opposed to a licence, or there is no real prospect that it's a sham, or whatever the defence happens to be.
That's of course exactly right. But what Lord Neuberger concludes at the end of paragraph 60 is he thinks it would be relatively rare for that to happen in the discrimination context. I submit it's relatively rare in a lease license dispute because it so often turns on to whether and to what extent someone has been given exclusive occupation. Baroness Hale agrees at paragraph 36. I think it's fair to say that there's a typing error because she refers to paragraph 59 of Lord Neuberger's judgment. But given the substance of what she says, I think that almost certainly refers to paragraph 60.
No.
And the other members of the court explicitly agree as well.
59, I think she agrees the case could be summarily disposed of if the landlord could show the defendant had no real prospect of proving he was disabled and so forth. So that is 59.
My lord, that's quite right. And then she goes on to say, like him, I suspect that the case will be rare, which is 60. It may well be that she's agreeing with both, and forgive me for insulting her if I say it's a typing error. It may well be completely correct. So that, my lords, my lady, I say, is absolutely the most authoritative statement of the law on 55.8. And it is entirely consistent with the principles relating to summary forms of determination in various different contexts. And just to give two brief examples, at paragraph 59 of our skeleton argument, there's a reference to...
Sorry, just before we move on, can we just look at paragraph 35
of Ackerman Livingston?
Lady Hale? Yeah. So she's well aware that these are listed on the basis they'll only take a few minutes each. Then she refers to the rule. Then she says the case can be summarily disposed of at the first hearing or later.
Yes.
And the court can do that without the summary judgment provisions of the CPR being invoked.
That's right.
If the court can decide summarily without invoking CPR 24, it must be applying the same test, mustn't it?
My lord, certainly a very similar test.
Sorry?
Certainly a very similar test. I would accept that. But certainly no higher.
No, well, I'm not sure that Mr. Grundy seriously pursued the higher test. You're seriously pursuing a lower test.
I am.
If you're right, then it would always be necessary to invoke Part 24 in order to obtain summary judgment, yet Lady Hale says it's not.
Not necessarily always, my lord. If we have a case like this, where there is a fully pleaded statement of the case, then the parties are in no worse position, the court's in no worse position as it would be in summary judgment, except, of course, summary judgment envisages that there will be some evidence in Part 55, doesn't it? So in a case like this, where the parties' positions are fully pleaded, the court can comfortably apply a summary judgment threshold.
Right.
In another case, where a tenant is unrepresented, like Stevenson, where they've got a disability, where there may be any number of factors that put them at a disadvantage, it would be unfair to apply a summary judgment thresholds in that context.
At the first hearing?
At the first hearing.
Well, that may be right.
Yes, but the test is still the same. The test is still whether the claim is genuinely disputed on grounds that appear to be substantial. So I accept that there's some fluidity in the test, and the threshold, the arguability threshold, may be appropriate in some cases and not others. And that's consistent with High Court authority as well. But I accept what my lord says, that in some cases there is no difference in practice between a summary judgment procedure and a Part 55 procedure.
When you said it was unfair, you meant procedurally unfair.
Procedurally unfair, yeah.
But the test is the same. The substantive test is the same. You're just saying it might be procedurally unfair to determine the case summarily under Part 55 at the very first hearing.
Yes. Using
But that's not saying that the substantive test you'd apply is any different.
It would be procedurally unfair to use the summary judgment threshold when one has, for example, an unrepresented defendant or a defendant who's not particularly capable of pleading a defence.
Well, I don't see that at the moment. I think you'd be saying it would be procedurally unfair to determine the case because the person didn't have representation or otherwise. I don't see why you link the procedure and the substance. I mean, procedurally, it might be unfair to determine on whatever standard because the person hasn't had a chance to get proper legal representation, etc.
Yes.
That doesn't mean you apply a different test.
Um,
I mean, otherwise, everybody would turn up to the first hearing, say, I haven't had any chance to get any legal representation, so you have to apply the lowest test to me. Because the last thing I want to do is to actually turn up with legal representation or have a second hearing, in which case I'd have to I'd have to satisfy a higher threshold. That can't be right, surely.
My lords, the High Court, as I'll come on to show you, has fairly consistently applied an arguability threshold, which in many cases is appropriate. There are some cases like this one, where both sides are fully represented, where one can look ahead and say, would this defence apply the summary judgment application, and apply a more rigorous standard, because we're talking about shutting tenants out of defending the claim. It's a draconian step.
So is allowing somebody to be made bankrupt.
Yes, of course. Yes, of course. But what can't be right is any tenant who turns up, if the court's unwilling to adjourn the claim, has to satisfy the summary judgment procedure on assertion alone. Has to satisfy the summary judgment threshold, forgive me, on assertion alone.
That's not my lord's point.
I'm sorry, my lord, then I misunderstood.
It may be procedurally unfair
Yes.
when the tenant turns up to decide the case there and then,
Yes. Yes. But
as in Stevenson.
But that's what 55.8 requires the court to do. It requires the court to consider, do we decide the case today?
Yes, it does.
Applying the 55.8 threshold.
Well, no, the court could, but the court can also adjourn the first hearing. That's what the opening words. Why I asked you to look at it before we got into this. At 55.8, it says at the hearing fixed in accordance with Rule 55.51, which is, you say, the first hearing,
Yes.
or at any adjournment of that hearing.
Yes.
The court can X, Y, Z.
Yes. But that leaves us with the possibility that the court refuses to adjourn and says, I am going to decide that on the merits of your defence.
But that may be procedurally unfair.
Yes.
But what I'm saying is, I don't see at the moment why you apply a different substantive test at whenever you come to apply the test.
The reason being that Part 55 is specifically designed to be more procedurally to be less procedurally rigorous. One has unrepresented tenants, one has represented tenants, and the courts have got to take a more tailored approach to the circumstances of the case.
All right, we understand your point. Now you're going to show us some High Court authority.
Yes, I'm grateful, my lords. And as I say, our fallback position is no higher. There's a series of High Court decisions which are cited in my skeleton arguments at paragraphs 46 to 50. 46 to 50, my lord.
In which page in the bundle? I think I've got it. 162.
I'm most grateful, my lord. 162.
Yeah. We got these.
Some of them, my lord. The rest weren't disputed. I accept they're not hugely authoritative, partly because they're High Court and partly some of them are first instance.
Well, you better just show us one or two of them at least.
Yes. So the two that are in the bundle are Cange and Evans.
Right. Tabs.
Cange, my lord, is tab 17.
Yeah.
And this is a case in which it concerns a garage, curiously enough. The claimant granted a lease of a garage to a company, and the occupiers seem to have been living in it. And the defendant's wife filed a witness statement which appeared to suggest that the defendant himself had exclusive occupation. And at paragraph 21, Mr. Justice Peter Smith says that the witness statement contained an assertion of a defence, and says it was at least arguable. And that's even in a case where, as the judge noted, the tenant was in serious difficulty making out their defence on the facts of the case. And His Honour Judge Luba cited Kanj as authority for his view that there should be an arguability threshold.
Yes.
So that was binding on him, and he was of course right to follow it. I also submit that His Honour was absolutely right to say that it was a low hurdle, and it's a low hurdle by design. Tenants and occupiers ought to be able to defend their homes if there's an arguable defence. And as I understand it, Global 100 must be inviting the court to conclude that those high court cases that I've cited were wrongly decided. I would urge the court not to do that because they're consistent with Eckham and Livingston. And I would say they're consistent with Stevenson, to which my lord and my lady have been referred. That was a case in which, as we've seen, the court had almost nothing before it, just the bare assertion of the tenant's solicitor. The court had still erred by making a summary possession of the property in that case.
Yes.
Now,
Evans, you also referred us to.
Yes. Evans, the judge below, also cited.
And what Mr. Justice Ramsey said there in paragraph 19, this was a case which, in a busy possession list, the judge should probably have considered the defences, and although there is strong evidence one way, there was also evidence the other way. I do not consider that this is a test where either approaching the matter with a summary judgment test in mind, or a test under 55.8, the court could grant. So that doesn't suggest that there's a lower test. It looks as though the two tests are equivalent.
Certainly the courts have made comments along those lines before, but if one goes ahead to paragraph 23, he dismisses another limb of the defence on the basis that it's not a seriously arguable case. He says then, or a case which complies with Rule 55.8.
Yes.
Which again suggests that there might be a difference between the test. But then he goes on to say again, not a seriously arguable case. So he does, yes, no, my lord's quite right to say that he does seem to notice a distinction between the two tests.
Yeah. Yes.
My overall submission, though, is that that's not what's said by the Supreme Court in Eckham and Livingston. Lord Newburger doesn't put it as high summary judgment for practical reasons, which are appropriate to a case like this. My lords, issue 4, unless my lords, my lady, have any further questions on issue 3, is whether the judge was right to overturn District Judge Parker's decision in respect of the lease licence. Now, Judge Parker, as my lord, my lady will recall, and we'll see from page 100, said that the case was in all essential points in line with Camelot and Coup. And the challenge for me, as I understand it, is to explain how this case differed from Camelot and Coup and from the Ludgate House decision. And there are, in my submission, 5 reasons why this is not, as my other friend puts it, a vanilla guardianship arrangement that was foreclosed by authority. The first is the most straightforward, and it's the AG Securities in Vaughan, Street and Mountford point about the factual realities prevailing over the language of the lease. One can't contract out of the Rent Act, now replaced by the Housing Act, and whatever the agreement said about access or exclusivity or anything else, if the occupiers were in fact granted exclusive possession, then the facts must prevail.
Yeah.
And the courts will note that, of course, both Coup and Ludgate House were heard by fact-finding tribunals at first instance, but no one has yet heard the facts of this case. The second point that is in both Coup and Ludgate House, the agreements emphasised that the guardians occupied the whole of the building in common, and in those cases, because of that, it was up to them to arrange how the sleeping spaces would be allocated. In Coup, but by the time the claim was brought, Mr. Coup was the only occupier left, so notionally he could have slept anywhere he wanted. The entire building effectively was his. And in Ludgate House, as my lord found, some of the guardians were staying in very ill-defined parts of the building, separated by hanging fabric, and indeed the upper tribunal found that it was not possible to identify the boundaries of each guardian's occupation. Here, if we look at page 242 of the bundle, hearing, this is the agreement between the NHS and Global. Just by the second hole punch, the agreement provides the property requires a suitable number of guardians for the protection of the building, with each guardian having their own lockable space.
Yeah.
So it's saying to the owner, don't worry, they're going to be in their own discrete rooms, which are going to be spread around the building. And that's repeated in the agreements with the guardians themselves. At page 253, and it's paragraph 1.5, or clause 1.5. And it's a point that my Lord Justice Snowden has already pointed out. There's some tension in clause 1.5, because on the one hand it says there's no right to use any specific room. And then on the other hand it says you will be allocated a space within the property. But in any event, it puts us in very different territory from what was one of the determinative factors in both Coup and Ludgate House. And in fact, if we look at page 255, we can see what a nonsense this agreement is, because clauses 4.2 and 4.3, just between the two hole punches, are said to apply, are said not to apply, forgive me, where the guardians are in single occupation or self-contained flats. So with the exception of those two clauses, this agreement is supposed to apply to self-contained flats. That, in my submission, is an obvious sham, or would be an obvious sham in a self-contained flat case, and it's something that the court ought to bear in mind. In both Ludgate House and in Coup...
Sorry, just explain that?
Yes, my lord.
Because on different facts it could be a sham, therefore it's a sham?
My learned friend was at pains to point out that the starting point is the agreement itself.
Yes.
Now, regardless of the fact the agreement says that we shall not keep it tidy and shall not report any damage, it's an agreement that says even in a self-contained flat, you are a guardian, you are a licensee, you do not have exclusive occupation, you are not a tenant. So it's difficult to take this document very seriously.
Sorry, I don't quite understand that. This condition does not apply to those in single occupation of self-contained flats.
Yes.
I own a flat.
Yes.
I want guardian services provided for my flat while I'm away. So I engage a company like GGM and they put in one guardian to guard my flat. Well, why is that a sham? I mean, obviously, the single guardian can't ensure there is at least one guardian in the property at any time. Otherwise, that guardian will never be able to leave.
Yes, it's a sham, because what was determinative in coup and what this agreement tries to emulate is that it's not one person it's that it's lots of people occupying in common rather than one person having an exclusive occupation of any part of the building. If there is only one person who has the right to shut the door against everybody else, that can't be the situation that was found in coup and the situation that was found in Ludgate House. You've got one person in sole occupation of the building, so they're not sharing, they're not occupying in common. They are the sole occupant. So everywhere that the license agreement says you are required to share the building space with everyone else is a nonsense.
Yeah, I see.
In both Ludgate House and coup, it was office space that was not suited to accommodation. My lord will recall that in Ludgate House, when the first Guardians moved in, it was just an empty office. There were no facilities, and they evolved over time. Whereas here, the fabric of the building appears to have been designed as individual units of living accommodation. It was nurses' accommodation, and before it was an office space. And because it mattered in Ludgate House and coup that it wasn't designed as living space, and here it matters that it does.
Yeah.
The penultimate one is the rent sharing arrangement, which my lords will see at page 247, which Mr. Wanacott already mentioned.
I can't remember, was there such an arrangement in Ludgate House?
My lord, no. Ludgate House, freeholder paid a fee to the Guardian Company. And here, and because of that, my lord found that the Guardian Company was providing a service to Ludgate House. That's at paragraph 70 of my lord's judgment, if you wish to see it. Here the freeholder is receiving money from the Guardians, albeit indirectly. So it's supposedly receiving a service and being paid to receive that service, or and being paid in tandem with receiving that service. And the final point is that my lord emphasised in Ludgate House that a contractual right is a contractual right.
Sorry, just before you, sorry,
My lord, sorry.
I understand it's a difference.
Yes.
Sorry, can you just unpack why you say that the fact that the owner both receives the guardianship services and is in receipt of the revenue share means what? That the relationship between GGM and
Yes,
the occupiers is different?
It's two things, my lord. First, it undermines the point that my Lord Justice Lewison made in Ludgate House about receiving a service. It's difficult to conceive of receiving a service which one also is paid to receive. Second, and probably more importantly, Mr. Wanacott earlier described what he said was a vanilla guardianship arrangement. That the further we stray from that, the more things start to look like a sham. And where one has, instead of paying to keep a building secure, a freeholder benefiting from the money that the occupiers are paying to live in it, that starts to look more and more like an ordinary commercial residential living arrangement than a true guardianship arrangement in which services are provided to secure empty buildings.
Yeah.
The final distinguishing feature, unless I'm not satisfied, my lord, with that answer, is the point about never relied on, never exercised contractual rights. And again, if I may, I would go back to AG Securities in Vaughan on this point. And it's page 147 of the authorities bundle, page 462 of the report. And it's 462 at letter E, the second sentence of this paragraph. Clause 16 was not a genuine reservation for Mr. Antonides of the power to share a flat and a power authorised for the people. Mr. Antonides did not genuinely intend to exercise the powers, save possibly to bring pressure to bear to obtain possession. Clause 16 was only intended to deprive Mr. Villiers and Miss Bridger of the protection of the Rent Acts. Mr. Villiers and Miss Bredger had no choice in the matter. So it will turn on the landlord's or the licensor's intention. It's a question of evidence, and as I say, no one's heard the facts of this case.
Well, where do you plead that?
Sorry, my lord.
I mean, the fact that powers are unexercised doesn't take you anywhere.
It doesn't, no, exactly.
You have to say it was never intended these powers should be exercised.
Yes.
Now, what you say in your defence, page 105 of our bundle, is that certain of the clauses, and I assume they're the ones you're referring to, are not incompatible with exclusive occupation, in that the claimant does not exercise a degree of control over the defendant's use as would be incompatible.
Yes.
You don't plead it was never intended that any of these powers should ever have been exercised.
It's pleaded that it's pleaded that it's a sham, and that
Yes.
and material to whether it's a sham is whether.
Well,
those
it's pleaded that it is a sham for the reasons given in subparagraph 1.
Yes, and at the end of
In
subparagraph.
consequence of the factual realities as set out in 2.1.
Yes, and it goes on to say at the end of paragraph 2 that the intention was to create the appearance of a license.
Yeah.
I accept there's no specific pleading concerning what the landlord or licensor intended, but again, it's everybody knew that this was a lease license dispute. Everybody knew that this was a sham dispute.
Yeah.
One of the relevant aspects of that is what did the landlord intend. Turning, if I may, to the judgment below and why I say it should be upheld in this respect. My submission is that the judge correctly directed himself in terms of threshold, but that I've addressed on already. At paragraph 85.
Hang on. Let me just get the judgment. He's talking now about Judge Luba, yeah?
Your Honour, yes.
Yes.
85, page 60. The judge correctly directed himself that it was very difficult for Judge Parker to decide the case summarily, given the very limited nature of the evidence before her. I took the judge's reference to evidence at paragraph 84 to be evidence in the technical sense, as it's meant under the rules, rather than evidence in the looser sense. But as I said under ground 1, the courts have repeatedly emphasised that where there are hotly contested issues of fact or law, it's often, very often, just unsuitable to determine them summarily. And he was correct to direct himself in that respect. Paragraphs 88 to 91, he again correctly directs himself that it's not possible or not appropriate to summarily determine a lease license dispute that turns on genuinely disputed issues of fact or assessment, echoing what Lord Neuberger said.
Yeah. I haven't looked at Ibrahim and Haringey. Is that something I should look at?
Mr. Grundy shakes his head. It's not a point I pursue, my lord.
Right.
And at paragraph 67.
67?
67, yes.
Yes.
He correctly directs himself in terms of the approach the courts ought to take on appeal, and he says that he took his steer from this court. In fact, Lord Neuberger puts the point a little more strongly in Ackerman Livingston at paragraph 62, which, if I may, is on page 362.
Of the
Sorry,
Authorities bundle, forgive me, my lord.
Sorry, 67. He says that the message from Stevenson appears to be that, albeit whether to adjourn or proceed is a discretionary case management decision, the appeal court will interfere if what has been put before the judge is indeed an outline defence which raises a genuine dispute with the claim on what appear to be substantial grounds, and the judge was wrong not to identify it as such.
Yes.
Or the other way around?
I'm sorry, my lord.
Or the other way around? I mean, if you've got a defence which has been put in, signed with a statement of truth, if the judge is wrong to conclude that there's an arguable defence, a defence where a genuine defence where they're based on grounds that appear to be substantial, applying the right test, the right wording.
Yes, I see my Lord's point. In practice, it would rarely happen because it's often quicker to pursue a fast-track trial than appeal to the circuit judge. But notionally, yes. Notionally,
so, right.
Or, on my case, they could apply for summary judgment at a later point.
Yeah.
In Ackerman Livingston at 62, Lord Neuberger considers what remedy to be granted, and bear in mind that this is an appeal against a 55.82 decision. The court's concluded that the judge directed himself, and he says in those circumstances the appeal ought to be allowed unless we could be satisfied either that the judge had applied the right test, namely the threefold approach, which he hadn't, or he could properly have reached the same conclusion as he did, or if the claim, if he had applied the right test, he would have reached the same decision that he did, or if the claim was now remitted, it is inevitable that an order for possession would be made. So that's how Lord Neuberger puts the test for remedies on appeals of this nature. I think my last point is this: my learned friend submits against me that the judge below didn't say what we would have to show in order to prove the sham. He didn't go into a great deal of detail about what would have needed to be proved at trial. The first point about that is if one looks at paragraph 88.
88?
88, my lord, yes, where he cites Camelot.
Yeah.
He explicitly says that he read and understood Camelot, which cites AG Securities in Vaughan. So he's clearly well aware of what mislabelling means in the context of residential accommodation. But the other point is that by making this point, Global makes a rod for its own back, because if the judge had explained more thoroughly what would have been had to be proved at trial, the occupiers' understanding when they signed the agreement, how things worked in practice, whether the landlord intended to rely on various clauses, then it would have been more and more obvious that this was a case that needed to be tried. My lords, unless you have any questions, I think those are my submissions.
Sorry, I'm just making a note, Mr. Barlow. Yes, very succinct.
No, thank you.
Thank you very much. Do you wish to reply, Mr. Grundy?
Just very briefly, one of which cheekily is just to explain the Ackerman Livingston Lord Wilson point. It was that somebody who only had a licence was entitled to enforce a possession order. So going back to the Ackerman Livingston Lord Wilson's paragraph 70 little I, the court didn't bulk at a mere licensee enforcing a possession order. Summary judgment. It's been bandied about that somebody who is pursuing a possession order could go for summary judgment. That's right in some cases. I just thought the court ought to know that under CPR 24.3 Rule 2, a mortgagor or a tenant and person holding over after the end of his tenancy whose occupancy is protected within the meaning of the Rent Act or the 77 or the Housing Act 88 cannot, again, a claim for summary judgment cannot be brought.
That's all because it's got to be reasonable to make an order.
Yeah, that's absolutely right. But it's not in every case that a possession...
No, you can't get a default judgment either. So
absolutely.
Yes.
But that's dealt with really by my learned Lord Snowden's point that this evaluation of under 55.82 could A, happen at the first hearing or at a second hearing, and it could happen again. There's no reason why because that's what the rule says, or at any subsequent hearing. So it could be that case management directions are made, a defence is put in, a defence not having previously been put in, and the landlord could say under 55.82 this doesn't raise any arguable defence. And I would submit that that is more consistent with Baroness Hale's position in Ackerman Livingstone than you could make a claim for summary. You could alternatively make a claim for summary judgment. In response to the submissions of Mr. Bano, all that the district judge had to go on was the defence. His Honour Judge Luba seems to think that because the defence was drafted by specialist counsel and was long and was met by a skeleton argument of 17 pages, because it raised 6 defences, 5 of which, it's now not disputed, didn't overleap the hurdle, that this was a case in which case management directions should have been made. In my submission, what the district judge had to do was assess by reference to the defence drafted by my learned friend whether or not any of those did satisfy the test. Not some other defence arising as a result of the construction of the agreement between NHSPL and GGM, which was available to my learned friend when he drafted the defence because it had been part of the bundle that was served on his client with the possession claim. I have, my lords, that's it. My lady.
Right. Thank you very much. Well, there's obviously a lot to think about, so we will, and you will get draft judgments in the usual way. It will be your opportunity to correct our English but not our reasoning, and we would hope that in the light of the draft judgments you will be able to agree in order disposing of the appeal. If you can't agree in order disposing of the appeal, please make short submissions in writing, and we will make the form of order that we consider to be appropriate. Thank you very much for your arguments.
All right.